Good evening, friends. Before we go towards the session of how judges decide the insights into the judicial reasoning and decision making, I was just reading an article. It was always said that once you know the law, you can get the case decided. But if you know the judge, you can get the case decided in a better way. And it was always one sided of prism that you always thought that what do you mean by that? Thereafter, I realized that it actually meant that if you know the judge, then you get the case decided in a better way. It meant that if you know what the judge wants, how he wants that you should present the case, whether he wants the facts to be told first and then the law, or when he wants that there should be a juxtaposition of the law as well as facts, or he wants the evidence to be read. That is what you mean that if you know the judge, you can get the case decided in a better way. And this is a session where we get the insights from a former judge, Justice Manju Goel, into the insights, how judges decide, insights into the judicial reasoning and decision making. We are so glad that Justice Manju Goel has been patronizing the channel of Beyond Law CLC, wherein she has been sharing her knowledge. Amongst us, we have former judge from Bombay High Court, Justice Roshan Dalvi, and those who have been connected with Beyond Law CLC know how Justice Roshan Dalvi has been sharing her knowledge. At the end, we will ask her suggestions as well as her inputs. But over to you, Justice Manju Goel, and thank you for accepting our invite.
Now it is all right. Is it all right? Okay. Now, good evening, everyone. And I'm thankful to all of you to spare your Sunday evening for this talk. I don't know. It's no substitute for the entertaining things we generally do on Sunday evenings. But still, I've taken courage to say a few words on something that we all know. This is not something new. Am I visible on the screen? Am I visible on the screen? Okay, but I don't see okay, fine. If you are seeing me, it's fine. So I will make a few attempts to just put together the ideas that go into making a decision by a judge. I'm making a difference between the decision and the judgment, because judgment is narration of what we decide and how we decide. So the question here is how judges decide, and we are going to deal with that primarily. This is not something generally which we do in the judicial academies, how to write out a judgment, but this is how we decide. Now, to start with, let me thank Vikas and this group Beyond Law for doing this excellent job of educating anyone and everyone who wants to learn anything about law. Week after week, month after month, and year after year, and hundreds, I have lost count. They only can tell how many webinars they have done and how many different topics they have taken for understanding the law, and how the recent developments in law or recent ideas in law have been discussed on this platform. Now, as I said, this is nothing new. Everybody knows how the judge decides, but just now putting them together means a lot of introspection. And every time I'm invited to speak, I do this introspection. I know the subject, but how do I express myself? As the theories of education say, you retain 5% of what you hear, but you retain 80% of what you learn by doing. And when a learner teaches another learner, he learns even more. So I'm in this last category. I'm a learner. But when I speak on the subject, I learn yet more. And this topic, how judges decide, is being done with a special reference to judicial reasoning. I've been a judge for more than 50 years. Yet, when I'm invited to speak, well, I thought it is going to be something very challenging. Particularly if there is a layman, I don't know when to begin, where to begin, what to explain and what not to explain. Because all that I will say will include so many legal jargons that it will not be possible to go beyond a few minutes. And on this, I read Benjamin Cardozo himself when he was invited to speak on this subject, and he says, I quote, "The work of deciding cases goes on every day in hundreds of courts throughout the land. By judges, any judge, one might suppose, would find it easy to describe the process which he had followed 1,000 times and more. Nothing could be farther from truth. Let some intelligent layman ask him to explain. He will not go very far before taking refuge in the excuse that the language of the craftsman is unintelligible to those untutored in the craft." Unquote. Judges decide and write in detail how the decision is arrived at. But much goes before the judgment is written. In fact, the judgment is written after the decision is arrived at. Now, what goes into making this decision? Do the judges read the evidence on record and just decide as to who is more convincing than the other, and the judgment goes in his favor? Now, before going to the evidence stage, the plaint and the petition has to be scrutinized. Is the suit or petition maintainable in law? Is the suit barred by limitation? Has the plaintiff correctly valued the suit? Does the court have the territorial and pecuniary jurisdiction to decide the suit? More preliminary questions like whether the suit has been filed by a competent person or whether the defendant has been correctly described. And there are many other things like an unregistered firm is not a legal entity, cannot sue and cannot be sued. Is the state a party? If so, who is representing the state? And then there are questions about people of unsound mind, minors, company, society, association, so on and so forth. And there are still many more questions which cannot all be listed in one go. Locus standi, for example. Frame of the suit, for example. So all these preliminary issues goes into the decision making. Sometimes these preliminary issues are taken up in the beginning and the suit may go on or die there. But sometimes they are mixed questions of law and fact. And therefore, you have to go on with the trial till the end and then decide. I remember a case in which the defendant in a matrimonial case was said to be a person of unsound mind. In fact, the ground for divorce was that the behavior of the man is so peculiar that it adversely affects the petitioner, the plaintiff, and worked as cruelty. So if that person is of unsound mind, the court has to appoint a guardian for that person. And my predecessor actually interviewed that man, and she felt that, okay, he can look after his case. He was okay, and no need to appoint a guardian for him. So that was once that decision has been taken and no appeal against that. I had to go on with that. And eventually the lady proved how the man had actually behaved. So, I don't want to go into how that case was decided. Dastane versus Dastane was the leading case which I had to use in showing that in a matrimonial case, it is not the conduct of the respondent, but the effect of his conduct. And therefore, I held that although he may be otherwise innocent, not knowing what he was doing, his actions were actually working as cruelty to the wife. So sometimes you have these very peculiar cases in which you have to do this splitting of hair to find out the next step. Now, when it comes to taking of evidence, it is a technical matter. Now, these technicalities are available in the earlier we used to do Indian Evidence Act, and now it is Bharatiya Sakshya Adhiniyam. The act lays down in detail how the examination chief has to be recorded, how cross-examination has to be recorded, when secondary evidence is admissible, how to prove a document, and then there are all rules given there, what can be presumed, what must be presumed, and what are the conclusive proofs. What evidence is more reliable than the other? This is decided partly by law, partly by judicial precedents, and partly by the sheer common sense and sensibility of the judge. Now, the decision making is a continuous process, but it looks that after the parties avail of their opportunity to lead evidence, the final act of deciding begins. Sometimes the decision is writ large on the file. Nonetheless, the entire process must be gone through before the actual judgment is pronounced. After the entire evidence is recorded and the lawyers of the parties have made their best efforts to convince the judge of their own cases, the judge announces the judgment. The task of the judge, or judging as it is generally said, has two basic parts. First is deciding on the facts. For this, evidence has to be collated and marshaled. Evidence is not recorded in a chronological sequence. It's not like a chronicle. We record evidence in whoever witness is available first, and not knowing in the sequence of events where his statement would fit in. So once that total evidence is taken, we have to collate the evidence in such a way as to make it readable as a story. Then after this is done, the work of appreciation of evidence will start. This again is a very, very technical job. It is not correct to say that the judge merely thinks who is looking more truthful. In fact, under oath, every witness is expected to speak the truth. So unless there are reasons to disbelief, the judge is expected to believe that witness. And if the judge really wants to somehow overcome the testimony of a particular witness, The judge must find the reasons for disbelieving that witness within the four corners of the file itself. Second, once the facts are established, the judge has to take care of the law applicable. This may be tricky. Law has to be interpreted in correct perspective. The statutes do not always cover all possible situations. There may be some gray area which needs to be covered by interpretation. Now, there are rules for interpretation of law which has to be applied for interpretation of a statute, whether you are before the Supreme Court or before an ordinary magistrate. And how law skips sometimes important phraseologies, like we have section 2 always defining the terms in the act. I remember in one judicial officers group, when I wanted to speak to them on Hindu Marriage Act, they all said that they know everything about the Hindu Marriage Act because they had prepared themselves for a departmental examination. And so I said, please close the books and tell me what is marriage. Don't open the book. So they all told me what is marriage in their own language. And the board was full, what is marriage? And then I said, now you can open the book and see. And marriage was not defined in the Hindu Marriage Act. So sometimes there are such situations, such important things. You may, or maybe if I'm asked to define marriage, it's going to be very tough for me, undoubtedly. Now, what the steps that judge has to go through? Step 1, as I said, are the facts, marshalling of facts, understanding the facts, deciphering the factual situation, which judge thinks is proved. This is what is proved. Then we have issues of law, what to apply, how to apply, and things like that. And the third, arriving at a decision on the basis of the law, facts and law as we have found. Now, in finding the facts, don't overlook the technicalities. There are things which can be proved. There are things which cannot be proved. For example, in a civil suit, facts and pleas not pleaded cannot be proved. Is there an echo? If the execution of an agreement to sell is admitted in the written statement, but the agreement is challenged on the ground of fraud, the defendant cannot lead evidence to prove that the signature in the document is forged or that he was coerced into signing the document. You see, it is for him to take what defense he wants to take. Now, in the defense, he does not deny that there is an agreement and he signed the agreement. But in the evidence, when he comes, he says, no, this is not my signature on this document. Now, the court, I'm sorry, the judge will not be able to accept this kind of a statement because his pleadings say that he signed the agreement. So this is to be remembered by the judge, what can be taken in evidence and what cannot be taken in evidence. Then there are rules saying documentary evidence to be preferred over oral evidence. And then once you have written down an agreement, oral evidence cannot be led to change the terms of the document. Very complicated section we all learn for our LLBs and thereafter. Then there are categories of witnesses which we call like chance witness, interested witness, police witness, inimical witness, so on and so forth. In every case, the judge has to take a view in the circumstances of the case, but the view has to be based on reasons and the same has to be expressed in the judgment. There is no settled down rule that interested witness, therefore, reject. There is no such rule. But we always look at the interested witness with a little bit of suspicion. But we cannot say that he is interested and therefore must be telling lies. This is not permitted. Now, sometimes the point in issue that seeks adjudication is entirely subjective. For example, in a divorce case, whether the husband behaved cruelly by his utterances and postures is entirely a matter of subjective evaluation. Unless any precedent holds the field, the finding has to depend on the sensitivity of the judge and his understanding of the social realities. For example, the husband says, I will deny that I am the father of this child. Now, this is a very fine thing for the judge to appreciate whether it means cruelty to the wife or not. So, there are such very peculiar situations when the sensitivity of the judge only will help. In a criminal case of murder, for example, whether the act was committed on grave and sudden provocation depends on subjective evaluation of the situation as proved. But then, when the judge says there was provocation and grave and sudden provocation, the judge must delineate the reasons for so holding. There has to be reasons for even subjective evaluation, and those reasons have to be based on objective standards. Res judicata, for example, a fresh adjudication is prevented because of the law of res judicata. Then we have the rule of res ipsa loquitur, which we use very frequently in the criminal cases. What I'm trying to say is all that the rules we know, that when you sit as a judge, you find that every rules call for more introspection, more reasoning, more analysis than what appears to anyone on the first look. I am proud to say that I belong to this group who always take the responsibility of holding. Like we write in our judgment, I am fully convinced. I have no hesitation to hold. These are our language. Other departments might say you may do that. I agree or disagree, but this strong language only the judges use. That there cannot be two opinion on this. The only inevitable conclusion is this. This strong language is written only by judges. Now, once the judge arrives at the conclusion of facts, following the reasons and legal principles described, he has now to apply the law and conclude the case. Supposing theft is proved, breach of contract is proved, dues of the plaintiff is proved. Now the next step is, what do I do? Now, whether it is punishment, then how much punishment? If it is a decree for what amount? Now, sometimes the law is clear and categorical, but the judge may not always be so lucky. So he then has to himself locate the law. So as I said, all through there is reasoning, reasoning, and reasoning. Now let us examine what is legal reasoning. Now, reasons mean guiding principles of human mind. When the man or any human being thinks there are two facts, and from this I infer a third fact, that is called a process of reasoning. So the common sense is applied, the first principles are applied. even in legal reasoning. Now, for example, a stolen property is recovered from a person's house. Now, anybody would suspect that he has either stolen the property himself or he has received it from the thief. And then in law, we may presume that he has stolen the property or he knows who the thief is. And now in this situation, if he says there is no mens rea, I have not committed any offense, then it is for him to take the onus on himself. So the onus that was on the police to prove the offense is now discharged, but then the onus then has to be borne by the accused or the defendant. Now perceptions differ from time to time. What is war, for example? Now, from childhood, we have been learning about wars. The war generally we think happens on the border, and some other foreign power attacks our nation, or there are conflicts between two foreign powers. That is war. But in the parliament attack case, which is reported as State of NCT Delhi versus Navjot Sandhu. The Supreme Court said that no, in the present context, law cannot always be understood as an attack on the army or the forces. This sporadic incident of terrorism can also be an act of war. So the Supreme Court said, and I quote, "It is not necessary that in order to constitute the offense of waging war, military or other forces should have been the direct target of attack. There is no such hard and fast rule, and nothing was said to that effect in the long line of cases referred to supra. The act of laying siege of Parliament House or such other act of grave consequences to the government and the people is much more reflective of the intention to wage war rather than an attack launched against a battalion of armed men guarding the border or vital installations." So now the Supreme Court arrived at this conclusion, I will say, on first principles, seeing the political and economic situation of the country. Another court may adopt it as an analogy, because analogy is also reasoning. But wait, we have a clear law making the courts follow the rulings of the Supreme Court. Thus, what is apparently an analogy actually this becomes a rule of law to follow the decision of the Supreme Court or analysis of the Supreme Court. The concept of justice and fairness also keep changing. So once a perception is recorded, it does not mean the same to be true for all times to come. But we have the law precedents, and once a legal perception is built by the highest court, it lies within the jurisdiction of that court alone to alter it as time needs. For example, this settled law that an agreement to sell immovable property, time was not the essence of the contract. But the times have changed. And taking note of this, the Supreme Court said that when the property values are subject to such quick revisions and escalations, the factor of time cannot be ignored. Then jurisdiction. The inherent jurisdiction of a court, for example, the trial court judge cannot give a decision on the virus of an act. It cannot declare a legislation of the parliament to be ultra vires the constitution. This is not to deny the trial court's prerogative to interpret the law. If a particular point has not already been interpreted one way or the other by the High Court or the Supreme Court, the interpretation part at least lies entirely in the hands of the subordinate court. The principles of interpretation is a field itself, field of study itself. And those principles have to be followed whether by subordinate courts or by the Supreme Court. Now, then finally, I come to the issue of judicial discretion. Now, discretion is not whims and fancy of the judge. Discretion is with the adjective judicial. So the discretion has to be used by the judge on grounds which are grounds which are based on reasons or grounds which are reasons themselves. Say a money suit, the plaintiff proves the dues, a decree must follow. Yet the court is left with the discretion about the rate of interest post decree. Depending upon circumstances, the court may allow the payment of the decretal amount in installments. Cost of the suit is granted to the winning party. Nonetheless, in certain circumstances, the court can withhold the cost. All these, in any case, will have to be based on reasons or grounds available on record. In a criminal matter, if the accused is found guilty, a punishment has to follow. For most offenses, maximum penalty is available in the statute. The court generally imposes a penalty below the maximum prescribed. This is an area of huge discretion. This area is currently controlled by prescription in several laws where the minimum sentence is also prescribed. So the discretion of the judge to that effect is taken away. For example, in a case of rape, the minimum penalty is 7 years. And for more serious offenses, 10 years. The judge's discretion cannot go below the minimum prescribed. For certain offenses, if the judge is allowed to impose a sentence below the minimum, the statute itself will say that this is possible only on special reasons. Then the judge has to write the special reasons. And even on these special reasons, we have opinion of the Supreme Court and the High Court. And therefore, the judge has to keep in mind those interpretations made by the High Court and the Supreme Court on what is the special ground for a sentence below the prescribed minimum. Now, when the discretion is available, the judge must use the discretion. If the discretion is not used, judge should say why the discretion is not used. For example, there are settled principles on which bail is granted or on which bail is refused. Yet, the bar marks the judges as lenient and strict in the matters of bail. So this, sometimes there are borderline cases, sometimes they are mere perception, and sometimes it may be some judges have more faith that the accused will come back for trial, and they may be more lenient in granting bail. Then there is this huge power of anticipatory bail. So this runs contrary to the power of the police to arrest without warrant. When certain judges, certain high courts wanted to put fetters on this power, the Supreme Court came forward to protect the power of the session judges for grant of free arrest bail, or what we call anticipatory bail. Can I take 1 minute's break for a glass of water? In the meantime, Roshan may comment on whatever has happened so far. I'll take not long.
This is a vast arena that you are going through. So I would rather wait until you finish, Manju. But while you are on discretion, I may mention just one thing about discretion for what you have mentioned already. Now, there was this discretion under section 376.
Can I continue with the session judges? Now, session judges' discretion to grant anticipatory bail. And when the Supreme Court protected this power against the fetters imposed by the High Court, the Supreme Court said the following. Please hear this very carefully because I have loved this paragraph. Generalization on matters which rest on the discretion and the attempt to discover formulae of universal application when facts are bound to differ from case to case frustrate the very purpose of conferring discretion. No two cases are alike on facts, and therefore courts have to be allowed a little free play at the joints if the conferment of discretionary power is to be meaningful. There is no risk involved in entrusting a wide discretion to the Court of Sessions and the High Court in granting anticipatory bail because, firstly, these are higher courts manned by experienced persons. Secondly, their orders are not final but are open to appellate and revisional scrutiny. And above all, because discretion has always to be exercised by courts judicially and not according to whim, caprice, or fancy. On the other hand, there is a risk in foreclosing categories of cases in which anticipatory bail may be allowed because life throws up unforeseen possibilities and offers new challenges. Judicial discretion has to be free enough to be able to take these possibilities in its stride and to meet these challenges. Unquote. Now, Supreme Court being Supreme Court, they could have said it in just one sentence. But put how many arguments they have given to protect this power? How many arguments they have given to be convincing that they are not being only sort of authoritative. They have given full reasons at every step. And so many reasons are available in this paragraph. Now, judicial reasoning is not like reasoning in science and mathematics, where every time a problem is taken up, the solution would be the same. judicial reasoning, though would generally produce the same result in the hands of various judges, there may still be possibility of producing different results. The same can be seen in the matter of injunction in civil side or in the matter of appreciation of subjective things. A huge area of fine balancing act of judges have to do is the area when the judges have to decide whether a particular murder convict deserves death sentence or life. The well-known phrase, rarest of rare, is not easy to apply. No two cases are alike. The judge therefore uses his own concepts of crime and punishment. In the very well-known recent case of rape and murder of the young doctor at the Arjikar Medical College and Hospital, Sanjay Roy, who was found guilty of murder, has not been given death sentence. The young doctor was raped in the place of duty. Her dead body showed many injuries and bleeding from several parts of the body, including eyes and private part. Sanjay Roy was a police volunteer entrusted with the duty to protect citizens. He used his identity of a police volunteer to enter the hospital premises and commit the crime. Still, the court did not bring it in the ambit of rarest of rare case. Now, we still have to see what happens in the High Court, where the state has gone in appeal. Now, I don't know where to stop because I didn't know where to begin. But I think I've said enough. And I conclude here. Thank you for your patience. Vikas.
I will ask Justice Dalvi, or before that, we will ask Ma'am Saxena to share her insights. I will check it out if they are unmuted. Saxena, ma'am. Poonam Saxena, ma'am, you will have to unmute yourself.
Yeah, thank you so much, Justice Manju Goel. It's always a pleasure to listen to you. And you have explained in detail an area that is so vast. You can speak, I know, knowing your capabilities and your, Benjan for speaking, you can speak for hours on this particular subjects. But it was really a pleasure to listen to you. Thank you so much. I enjoyed it.
Justice Dalvi, ma'am. Thereafter, we will take few questions.
I think I would say ditto. It is such a vast topic, and it looks like she has taken us through the CPC, the CRPC, the Evidence Act, and all sorts of, the nuances of the law. I would only say one thing. Reason is logic in motion. It is the heartbeat of a judgment. Our judgments have to be based on reasoning. And reasoning is seen by all. Now, who are these parties who will see reasoning? One is the parties to that case, their advocates, the judge himself, the appeal court, the civil society, and so many other lawyers and litigants also who have nothing to do with the judgment but who want to rely upon paragraph 27 of the judgment only. But they will have to see the reasoning. Okay, so that makes it the heartbeat of a judgment. And that reasoning may come, as Justice Goel said, for various things: jurisdiction, limitation. You just finish off the matter. It is order 7, rule 11, order 7, rule 10, whatever it is res judicata, and all sorts of things have been compiled into the CPC. We can't think of anything more that could have come in. It's like the IPC, the Indian Penal Code. As we read through it, it runs like poetry. And we feel nothing more can be added. And yet there is one more thing. Yet there is one more thing. So that is how Manju Goel's lecture was. But saying that, this reasoning, how do we find? We go from a point of view to a viewing point in a judgment. That is the reasoning. Why? Now, even when we are talking, we say, no, he is right. We all the time say why he is right. He is wrong. We say why he is wrong. A child also, when the two children are fighting, they say why the other child is wrong. So reason is the hallmark of anything. It shows the mindset of the judge. It shows that the judge has applied his mind or not. And of course, the judge applies his mind. You may have another opinion. And this is brought out in what kind of judgments? I would like to only give the criteria. The judgment, when it is readable, understandable, clear, brief, simple, precise, systemized, affirmative, definitive, and transparent. The reasoning comes out, as they say, in Hindi or Gujarati, they would say, like nitru pani, like crystal clear water. It should come out. And it should reflect everything that is there. So if there is a river, if there is a lake, and the water is so crystal clear, all the trees, the mountains, you can look into the river. That is how the reasoning of the judgment is seen. And one judge, Justice Byron White of the US Supreme Court, said that this judgment which is clear and crisp, leaving as little room as possible for disagreement about its meaning. You may disagree with whatever is the ultimate judgment, because there are so many opinions that those are various points of view. But disagreement with the meaning cannot come if the reasoning is sound and proper. And the best thing that Manju Goel said is the last, the discretion. So often the reasoning gets blurred in the discretion which is used. Therefore, discretion used by a judge has to be not mischievous, not arbitrary, but judicial, as she said. That is the adjective. That's the correct adjective. A judicial discretion. Or I would say judicious discretion. Now, under section 376 of the IPC, there was discretion. You go less than the minimum sentence. Somehow, only in that section, there is this discretion granted. Otherwise, as Justice Goel said, the discretion is between the minimum and the maximum. The judges don't have any more discretion. Now, how was that discretion used? The judges give their reasoning. The accused is very young. The parents are very old. All sorts of things deny the reasoning of the law. It trivializes suffering. A woman has suffered under 376 rape, and you say he was young. Then if he is young, don't start the trial. He's a young man. Why do you go through the whole trial and then say, no, he will not get the minimum punishment also? Or if his parents are old, the same thing would apply. Now the legislature has taken away that discretion because it was not used. I recall Justice Goel and myself giving various workshops telling the judges not to use discretion like that. Because this reasoning shows their mindset. Oh, if the parents are old, then Janet, because who's going to support them? But you have to see what is the offense he has created. You may feel that he'll not get the maximum punishment, but minimum punishment because his parents are old. How can you go below that? So these are the reasonings which have shown how the judge's mindset is. That is their point of view. Okay? So everything is shown in reasoning, and reasoning must be there. Because, as another judge has said, a judgment with superfluous citations, inconsequential evidence, at the expense of essential reasoning is flawed. But a judgment which does not give reasoning becomes vulnerable. So, reasoning is that heartbeat of the judgment. Okay? And I think lawyers as well as judges can contribute to that reasoning. Because if lawyers also have muddled up things, their arguments are muddled up, then a judgment may not flow that well for the reasoning that is there. Okay. So that's about it for reasoning. Thank you, friends.
Thank you, ma'am. Like both of you, ma'am Poonam Saxena and Justice Roshan Dalvi has said, in Hindi they say Gagar mein sagar, and in the Shakespeare terms they say that brevity thy soul wit. So that is what we can sum it up what Justice Manju Goel has said. And I'm also reminded that once we take cue from this, I was just reminded that the art of advocacy lies in identifying the issue, mastering the facts, and applying the law with the precision. And like what Justice Dalvi has said, there's a famous judgment, I'm just taking it out, that was, yes, Kranti Associates Private Limited versus Masood Ahmed Khan. That is 2010, Volume 9 SCC 496, which we often as the lawyers use, that the reasoning are the links to understand what actually went behind it. And that is why they say for reasoning, not only for the judgments, but for the administrative orders or for any other matter, it has to be there. And few questions are there. I will, since we are well aware that Justice Dalvi as well as we have Justice Manju Goel also. Few questions on the session. I'm just taking. Ma'am, since both of you have been judges, few questions came. What factors most influence a judge while deciding a case?
What?
What factors most influence a judge while deciding a case?
What factors? I've described all the factors that the judge has to take. The personal likes and dislikes don't work. I like you, Mr. Advocate. No. I may be very kind to the advocate in the court and might smile at him 100 times. But the case is a case. The reasons are there in the file, and we have to decide on the basis of the file. The factors are all there. Apparently, there may be a feeling that this judge is kind of very angry with me. Doesn't matter. You come and do your case before the judge. If your case is good, you will get a judgment in your favor. Even though reluctantly, the judge will have to make a judgment in favor of your client. There is no special factor which I say will influence a judgment. If you have any factor in your mind, please come up so that I can understand your question.
Yes. What happens when the evidence is strong, but the legal provisions may be weak?
Evidence is strong, but the
Legal provision is weak.
legal is weak.
Yes.
So it will depend on the case. You see, if you don't have title, you produce 100 witnesses to say that you are the owner. But the law says how to prove title. So if you don't have the title deed, what will happen? You have lots and lots of evidence in a rape case, and the prosecutrix comes in the box and says, I was not raped. So there may be evidence, great deal of evidence, and eventually the law is, you believe the, you see, sometimes it may be different. I remember the case of a 4-year-old child who was kidnapped by a man, and she was recovered after 2 years by her parents. The child did not speak in court, but the medical evidence said so much. So it was a matter of appreciation of evidence. The child did not speak is not unnatural for the child not to speak. But the child spoke to the mother, and mother came and deposed that the child told me this. Now, although this may apparently appear to be a rule against direct evidence or rule against hearsay evidence, but then this is covered by the rule of res gestae. This was a natural thing for the child to speak to the mother when the mother recovers the child. And the mother is coming to depose, the child is not deposing. So sometimes you have such cases. But then I had full reasons for holding that the child had been raped. So if you give me a concrete fact, I might be of some guidance to you.
Ma'am, these are the questions which normally arise. I will ask Justice Roshan Dalvi that how does a young lawyer or I will not say junior advocates, those messages there, build a credibility before a judge?
The first thing is preparation. I personally believe that if a lawyer is not prepared, if he has not read the brief, and if he cannot answer basic questions, the substratum of being a lawyer is lost. So if even a junior lawyer, as you say, a young lawyer, has read the papers, the judges would always help them. And if judges help those who don't read the papers and are not prepared, they are not doing the best for the system as per their oath. Because we have to go on. You can't just come and not have it. Now, how would you be credible without being prepared? And preparation is the facts of the case and the law that is related to it. That much has to be there. I recall, and I've mentioned that in my book also, one lawyer made bold to want to talk to me. I always had this principle that I don't want any lawyer to come into my court alone. Both lawyers come or nobody comes. And you apply for whatever you want in my court because that gives the transparency. But he said, I just want to talk to her because I'm in some anguish, etc. And he was sent in and he talked with me and he told me that his senior did not want him to argue. His senior just wanted him to get the matters adjourned. He would not give him the brief to read. So he cannot be prepared because he knew I was always saying that you should be prepared. Now, I realized that this young boy just wants to get away with it and then feel very smart about it. And he was not so smart. I told him, okay, your senior does not give you the brief. Your senior sends you to my court. You know which matter you are appearing in, but you don't know the facts. My associate will give you the brief. You sit down and read here, and you tell me the facts. We will just get going. I will help you afterwards. He never came back to my court. Now, how is this lawyer going to be credible?
This is to Justice Manju Goel. What role does equity play in judicial decision making?
I couldn't get you.
Ma'am, what role does equity play in judicial decision making?
What?
Role
Can
does
we
equity,
slow?
ma'am, what role does equity play in judicial decision making?
Equity. Oh, very good question. I think it's a good question. Equity. Equity, you see, is written in the law, first of all. Written in the law. And if it is not written in the law, the judge has to balance the equities. Now, I said, you know, the money suit, for example, the bank sues a debtor. No bank suit is ever dismissed. There is no defense to a bank suit normally. I took the money, here is the thing, this is my account, the money came to my account, I have not paid back. Now, equity is, this is a poor man, and therefore, equity does not mean I absolve him of the dues. Equity means the bank must be paid. Equity means I should do justice to this man also. So equity will mean I might request the bank to settle the matter with him. we can do mediation in between. If that doesn't work, as I said, I can ask the bank to charge him lesser amount of interest, or maybe the judge has some discretion in the CPC to consider the rate of interest at which the repayment has to be made. And then I can say, you pay back in installments, but you have to be very sincere in repayment. Again, equities in favor of the bank has to be seen. It does not mean he gets away and doesn't make the installment. So we make an order, installment of so much, subject to the condition that if he defaults in 2 consecutive installments, then the whole thing will become recoverable at once. So these equities are there either in the act itself or thereafter when we make the judgment. See, even when you want to recover, how much leniency is given by the act itself to the debtor? Is it easy to recover money? So much of leniency is given to the debtor. So sometimes I feel equity is there and sometimes more than necessary equity is there.
Ma'am, we will take the last question. It says, how to improve the pleadings and the interplay of a lawyer. Like, let's assume if there's a young lawyer, how should he learn the improving of his pleadings? How to improve the pleadings, ma'am?
How to improve the pleadings?
Yes.
Well, now this is again a very good question, because when you draft the pleadings, don't draft the pleadings just like that. You must know what will happen at the end and what law you have to bring. So, therefore, you please see the provisions of the act, the law, and see where you have to stand, and then draft the pleadings. Even for the purpose of cross-examination, please see what question you are putting, what is the possible answer, and with that possible answer, what kind of benefit you can get. Don't just go on asking questions. Like I said, the man said he has signed the agreement, and then in the witness box, he thinks he can be smarter by saying, it is not my signature. So in these cases, you must, before you draft the pleadings, you should be careful what facts can be proved. Is the man stable? Tell your client that this is what I am writing. You will have to say this before the court. Don't prevaricate. And see on these facts, is a decree permissible or not? What is your weak point? And if you have a weak point, how to bridge that gap? So all these things have to be taken care of before you draft your pleadings. Whether you are making out a reasonable case and whether the case will stand trial, whether you have the witnesses to prove every stage, every step.
Yes, ma'am. And the last question to Justice Dalvi, how do you tell the lawyers and maybe the younger judges from the civil court and this thing, how should they read the judgments and should they apply those judgments while making submissions or pleadings?
They should read the entire judgment so that we don't pick up points from here there, because that kind of a practice has been deprecated by the Supreme Court often. When you read the entire judgment, you know how many different facets of the judgment are there and which out of those you are going to want to rely on. So then you go to those relevant paragraphs. And I used to tell all the lawyers that you mark the relevant portions. Because though I will read the entire judgment, it becomes easier to understand the mind of the lawyer also. Because the reasoning about why he is relying upon that judgment is equally important to me. Quite often you find that it's completely irrelevant and we don't rely upon that judgment at all. And that is exactly what the judge, when I cited him, said. Inconsequential evidence and superfluous citations. Just because the advocate has cited 5 judgments doesn't mean the judge has to rely upon 5 judgments. He may rely upon any one of them. That's all. So far as he does it as per the law, depending upon those facts, it's fine. So lawyers must know which judgments to rely upon and don't needlessly make large files. If there is one judgment which is followed in another and another and another, you have to rely upon at the most the first and the last. This is the latest judgment, of course, so you show that. But that is because the earliest judgment has stood its time. But the in-between judgments are not required. And only whatever is it that you are relying upon, not just verbatim any judgment, and you make a compilation and throw it up to the court. It doesn't make much sense. Okay, thank you.
Ma'am, for sharing your knowledge. In Hindi, there's a word that there is jugalbandi. So whenever both of you come, it's always a pleasure to understand the nuances of law, and we keep on receiving the messages from the various persons who wish to understand the things. And tomorrow, friends, we will be having a session on the lawyer-client conversation, from facts to strategy, as to what should be discussed with the client and how to extract more from him so that there can be better drafting or better consultation. That is by Manmohan Sharma, a former principal judge from Delhi High Court, and now he's an advocate. Do join us tomorrow at 5 p.m. And thank you, everyone. Stay safe and stay blessed. And thank you once again to Justice Manju Goel and Justice
Thank you.
Roshan.
Thank you, all of you.
Thank you.
Thank you. Thank you. Nice. Thank you, Manju.
Thank you.
Very good.